G'day everybody and welcome to week 7 of Laws 12063 Advanced Statutory Interpretation and Drafting. I'm Anthony Marinac. This week we're going to look at the two key pieces of legislation which govern statutory interpretation. These two pieces of legislation really are the Bible of statutory interpretation, and yet it's surprising how few lawyers and how few law students are really familiar with these acts and how they operate. The acts I'm talking about are the Acts Interpretation Act 1901 in the Commonwealth jurisdiction and the Acts Interpretation Act 1954 in the Queensland jurisdiction. What we're going to do today is go through some of the key areas that those two Acts Interpretation Acts govern, and we'll compare the Queensland and the Commonwealth provisions because you'll need to be familiar with both. Now, in the space of one lecture, we're not going to have the opportunity to go through them in some detail. You're going to have to do that for yourself, and you're going to have to keep doing that right the way through your career of practice. What we can do is look at some of the key provisions to give you an idea of what sorts of things you find in the Acts Interpretation Act and why it really is worth your while to make the effort to go through and look at the acts in more detail on your own. Towards the end of today's lecture, we're also going to take some time to consider some of the other factors that bind statutory interpretation. In particular, we're going to look at human rights and human rights as they arise from charters of rights or bills of rights, and also as they arise from international law. So at the end of today, we will have completed that part of the course which really focuses on statutory interpretation, and that will leave us in the position from next week to start looking at legislative drafting proper. So let's get underway. What are the Acts Interpretation Acts? Well, if you think about it, every act, every statute embodies in itself a whole bunch of basic principles. For instance, one of the principles we're going to talk about later on is the idea that in legislation a plural implies a singular and a singular implies a plural. So in other words, if there's an offence that is committed against a child, it doesn't somehow become not an offence because it's committed against 3 children. The singular implies the plural. Now, realistically, we could have a provision in every single piece of legislation on the statute book that says a single implies a plural and a plural implies a singular, but we would waste an awful lot of space and make our statutes awfully complicated. Another option is to have one piece of legislation where this one piece of legislation says for all statutes on the statute book, unless it's specifically stated otherwise, the general rule is going to be that the single implies a plural and the plural implies a singular. That's what the Acts Interpretation Acts do. They take rules that are in place, rules of interpretation that are in place across a whole bunch of pieces of legislation, and they bind them into one statute. So they really are the key to unlocking the meaning of statutes. They will help you to interpret provisions in statutes in the way that the Parliament intended. I personally believe that it is impossible to effectively interpret statute without referring to the Acts Interpretation Acts. It just can't be done. So what are the Acts Interpretation Acts? In the Queensland jurisdiction, we have the Acts Interpretation Act 1954. Now, this was introduced in the mid-1950s to replace what was called the Acts Shortening Act 1867. The Acts Shortening Act, as its title implies, was introduced in order to take a bunch of these common provisions and remove them from individual pieces of legislation so that they could all be read in one place. So you can see this idea of having an Acts Interpretation Act is not a new idea. This is something that has been around for an awfully long time. In the Commonwealth jurisdiction, the Acts Interpretation Act 1901 was the very first bill presented to the Commonwealth Parliament. Strangely enough, when it came time to actually pass the piece of legislation, which took a little while, this was the first bill to be presented to the Parliament, but it wasn't the first act to be passed because it took the Parliament a little while to consider it. When they came to pass it, they found that they couldn't actually locate that first bill. Some kindly person had stolen it because they wanted to souvenir the first bill ever presented to the Australian Parliament. Sometimes you read on Facebook or websites or wherever that the first piece of legislation dealt with by the Australian Parliament was the Immigration Restriction Act, which became known as the White Australia Act. That's actually not true. That act was neither the first presented to the Parliament nor the first passed by the Parliament. The first bill presented to the Parliament was the Acts Interpretation Act 1901. So you can see just how critically important the Parliament considers the Acts Interpretation Act to be. Before the Commonwealth Parliament even started legislating on anything else whatsoever, the very first thing that the Parliament decided it had to do was introduce an Acts Interpretation Act. It's that important. Let's have a look at some of the provisions and then you'll be able to see why Acts Interpretation Acts are so critically important to statutory interpretation. The first provision I want to look at comes up in section 15 capital A of the Commonwealth Act and section 9 of the Queensland Act. It says acts are read to be constitutional and within legislative powers. Now this will sound pretty familiar. You might remember a couple of weeks ago when we were talking about some of the common law presumptions that courts use in statutory interpretation. We talked about the common law presumption as to constitutionality. And we said that the courts will presume that legislation has been written in a way that is within the powers that the particular parliament has to pass legislation. That common law presumption still exists, but now it has been reinforced with a statutory presumption. Both Acts Interpretation Acts direct the courts when interpreting Commonwealth statute. They say to the courts, you are to read each act in such a way as to bring the act within the Parliament's constitutional and legislative powers, if at all possible. What happens if you've got an act where part of the act is within power and part of the act seems to be outside the power? Well, these same provisions direct the court, if at all possible, to divide the act into those parts which are constitutionally valid and those parts which cannot be given a constitutionally valid reading, and the courts should implement those parts of the law which are constitutionally valid. So you can see straight away, with the first provision that we're looking at in this lecture, we're dealing with big issues. We're dealing with the fundamental issue of whether a statute is constitutional in the first place, and the authority for that question, the authority directing the court in how it's going to be assessing the piece of legislation, comes from the Acts Interpretation Act. The second provision that I want to talk about states that acts are not binding on the Crown. This is an interesting one. There's a traditional assumption in common law rules of statutory interpretation that legislation is not binding on the Crown. So when a statute is introduced, it's binding on normal citizens, it's binding on corporations in their capacity as legal persons, but it's not binding on the Commonwealth Government or the Queensland Government, and it's not binding on public service agencies, it's not binding on ministers, it's not binding on any officer of the executive government in the course of their duties. Now at first most people are going to say, hang on, that doesn't quite sound fair. Well, it actually is pretty sensible if you think about it. The example that I've given in the notes refers to the tax office. Now, the tax office obviously receives income in the form of taxation when it levies taxes on people. Generally speaking, when an organisation receives income, it has to pay tax on that income. So, should the Australian Tax Office pay tax on the tax it receives? Pretty clearly it shouldn't. It's a bit of a silly idea. The old notion that acts are not binding on the Crown was designed to overcome this. It was designed to say, look, the reality is that government instrumentalities are a bit different. They are different from normal corporations or bodies corporate. They are different from normal people, and we need to make sure that the legislation treats them that way, or else things could get a bit silly. However, it's just a presumption. So the way it worked was that legislation was presumed not to be binding on the Crown unless the legislation stated that it's binding on the Crown. And if you look in plenty of pieces of legislation, usually in one of the very early sections, you will find that many pieces of legislation state that the Act is binding on the Crown. The example that I've given in the notes is the Environment Protection and Biodiversity Conservation Act 1999 in the Commonwealth. Now, this Act is intended to prevent people from taking steps which will cause harm to areas with national environmental significance. Now, it makes sense to me, and I hope it'll make sense to you, that the Commonwealth or its agencies, or a state government and its agencies, shouldn't really stand in a different position to anyone else. If a Commonwealth agency, let's say a Navy vessel, is going to do something which would cause damage to the Great Barrier Reef, well, it should be prevented from doing that, just in the same way that a commercial fishing trawler should be prevented from taking action that might cause damage in the Great Barrier Reef. So it makes sense for this piece of legislation to bind the Crown in the same way that it would bind anyone else. And so we find in section 4 of that particular act, it states this act binds the Crown in each of its capacities. So you can see we have a presumption that the act does not bind the Crown, but this presumption can be easily overturned by the Parliament if it's passing a piece of legislation which ought to bind the Crown. Now, that old common law notion continues in place in the Commonwealth. The Commonwealth does not have a section in the Acts Interpretation Act which considers whether or not acts should be binding on the Crown. In Queensland, however, in section 13 of the Queensland Acts Interpretation Act, it states quite clearly that acts are not binding on the Crown unless express words are included in the act for that purpose. The third provision I want to talk about relates to the question of just who is a minister. You see, plenty of pieces of legislation provide statutory powers to the minister or to the relevant minister. Now, that's pretty general language, isn't it? I mean, why wouldn't you just say the education minister or the defence minister? The reality is that the arrangement of the ministry changes very often. Every time a minister retires or resigns, every time there's an unsuccessful leadership spill, every time there is an election and a new government returned, and sometimes for purely political reasons. A premier or prime minister may change the composition of their ministry. Sometimes the ministry will change through unforeseen circumstances. Sometimes ministers will be overseas. Sometimes ministers will be sick. What happens if a minister is sick? What happens if a minister has a sudden heart attack? What happens if a minister goes swimming at Portsea and is never seen again? Who is going to be able to exercise those statutory powers while the minister is not there? What happens if there's a change in ministerial titles? You see, we talk about the idea of there being a defence minister. Well, it's not so long ago, in fact, the late 1970s and early 1980s, that you could look back and see that instead of having a defence minister, we had an army minister and a navy minister and an air force minister. So what if we had legislation back then that referred to the minister for the army, and we're still using that legislation now? Well, there's no minister for the army now. We have a minister for defence. So should the minister for defence be able to exercise powers that were given to the minister for the army? If we wanted to be that specific in our legislation, the only way to handle it would be that every time we had a relevant change to the ministry, we would have to go back and amend a whole bunch of legislation. That would be extremely inefficient and extremely wasteful. So the Acts Interpretation Act sorts it out. In both jurisdictions, in the Commonwealth in sections 19 capital A and 19 capital B, and in Queensland in section 33, each Acts Interpretation Act outlines that if a statute just uses the term minister without anything more, then the statute is taken to refer to whoever is the minister exercising the relevant powers for that statute at that time. So if they change the minister's title, doesn't matter. If a minister goes overseas and there's an acting minister, doesn't matter. If a minister goes missing and another minister steps in during the period that they're unavailable, doesn't matter. If a minister is commissioned as a minister with one particular title, and then all of a sudden the names of the ministries all change because of a ministerial reshuffle, the Acts Interpretation Acts say that the Governor or Governor-General can simply issue a proclamation to say, from this point forward, let's pull one out of our hat for an example. From this point forward, the minister who is now known as the Minister for Climate Change and Water Resources will be able to exercise all of the powers previously exercised by the Environment Minister in relation to water. And then each of the relevant pieces of legislation would be spelt out. So what you can see is the Acts Interpretation Act provide a series of default positions, and then they provide a series of mechanisms to enable the Governor to sign off on decisions to get us out of trouble if necessary. Now I bet that most of you have never stopped to think when reading legislation up to this point, who is the minister and how do we know? In most cases, of course, it's really obvious who the minister is and we don't need to ask that question. Sometimes it's not going to be, and that's where the Acts Interpretation Act comes in. Let's have another look at another section. This one's the real biggie. Acts are to be given a purposive interpretation. In the Commonwealth, this is found in section 15 capital A, and in Queensland it's found in section 14 capital A, subsection 1. In each case, the Acts Interpretation Act throws away the idea of a literal reading and says a purposive reading is to be given to Australian legislation. Now, the use of this provision is pretty interesting. I've indicated in the slide there that the purposive approach only applies to resolve ambiguity, and if the Act is clear, the court should apply it. However, the modern approach to statutory interpretation says that the court is allowed to take the purpose of the Act into account from the very beginning. So from the start of the court's assessment of the particular statute, the court is allowed to have in mind what the purpose of the statute is. And that understanding of what the purpose of the statute is may assist the court to determine whether there is ambiguity at all. You see, there might be a provision in place which appears to be ambiguous until you take into account the purpose of the statute, at which point it becomes clear that there's no ambiguity whatsoever. So the court is still not allowed to rewrite statute and to interpret statute based on what it thinks the Parliament was trying to say. However, when the court interprets statute, the court is allowed from the very start to bear in mind what the Parliament's intentions were, what the Parliament's purpose was in passing that legislation. So in Australia, the question as to whether we have a literal or a purposive interpretation of legislation is now completely and utterly resolved. In Australia, we have a purposive approach and not a literal approach. Next, let's talk about the provisions relating to extrinsic material. Now, we've talked a bit about extrinsic material in the course of our lectures over the last few weeks. Both Acts Interpretation Acts contain a provision which say that extrinsic material can be used to interpret legislation. Those provisions are found in section 15 capital A capital B in the Commonwealth legislation and section 14 capital B in the Queensland legislation. Extrinsic material can be used for three purposes. First, to confirm that words are being used in their ordinary way. So if there's an argument as to whether words are being used to give an ordinary meaning or whether they're being used to give a jargon meaning, the extrinsic material can be used to show that the ordinary meaning is intended. Second, extrinsic material can be used to resolve ambiguity in the text. So if the text of a statute is ambiguous, the court can look to extrinsic material to assist to determine what the purpose was, which will assist the court in turn to resolve the ambiguity in the assessment of meaning. And third, extrinsic material can be used to determine if the ordinary meaning would be manifestly absurd or unreasonable. So if the ordinary meaning applied to a piece of statute would result in an interpretation that was manifestly absurd or unreasonable, the extrinsic material can be used to show this. In effect, the result of these statutes is that extrinsic material can be used. We know from the provisions that we talked about just a moment ago that the court's going to be taking a purposive approach. And we know as a matter of sheer practicality that a purposive approach is usually going to be assisted by being able to have regard to extrinsic material produced by the Parliament, in particular by the government at the time that the legislation was being drafted. So whenever the court is following that purposive approach, it's quite likely that the parties before the court are going to seek to reinforce their position by reference to extrinsic material. I'm sure you can see already that the stuff we're talking about here are the key provisions, the key aspects of statutory interpretation. It just staggers me that people attempt to interpret statute without having regular reference to the Acts Interpretation Acts. Let's have a look at some other provisions. The next one I want to talk about is a provision that says that changes to drafting style don't change the meaning of provisions. Now this is found in section 15 capital A capital C in the Commonwealth and in section 14 capital C in Queensland. In each case, the legislation states, the legislation recognises that over time we have different processes, different standards for drafting statute. The plain English movement is the best example of this. Really, we've only seen the plain English movement pick up steam since the 1980s. The result has been a complete and utter change in the way that statutes are drafted in a contemporary sense to the way they were drafted 50 years ago, 100 years ago, 150 years ago. The problem is that as soon as you change the style of language that's used when drafting statute, you potentially change the meaning. You see, if we're updating a statute and we change the style of language, the court's going to ask itself, why has the Parliament chosen to use new words? If the Parliament did not wish to disturb the meaning of the statute, why didn't the Parliament just leave the statute alone? Maybe the Parliament changed the words because it was trying to change the meaning. In that case, the court will start looking for what the new meaning of the term is meant to be. And as part of that new meaning, look at that search for the new meaning, they will discard the old meaning. Now these two sections in the Acts Interpretation Act, sections 15AC in the Commonwealth, section 14C in Queensland, they say to the courts, whoa, hold everything. A change in drafting style, if it's just an attempt to express the same idea using different words that are simpler and easier for people to understand, that is not necessarily a change in the meaning or an intended change in the meaning of the statute. Now this of course has made life more difficult for the court, because where the language of a statute has changed, the court now has to engage in the process of asking itself, has the language in the statute changed because the Parliament is intending the statute to mean something else? Or has the language in the statute changed because they're just updating the statute into a more plain English sense? Now, of course, sometimes that will go one way and sometimes that will go another, but through this section of the Acts Interpretation Act, the Parliament has at least said to the court that where a statute is updated just to change the nature of the language to make it more comprehensible, there is no intention to change the meaning. Next, let's have a quick look at gender. Now, we talked a couple of lectures ago about the importance of using gender-neutral language. Gender-neutral language is still a relatively new phenomenon. Up until at least the 1980s, it was very common, very normal for people to use the male pronoun as the default pronoun. Nowadays, we would regard that as unacceptable. And so nowadays, if we're using old legislation, which might refer to men or to he, there's a need to make it clear that in fact that statute is just archaic and using archaic language. That in fact, in those circumstances where a gendered word is used, the presumption must be that those gendered words imply every other gender. Gradually, of course, that's becoming less of a problem because as statutes get rewritten and updated, they are being rewritten into language which is gender neutral. Be aware, though, that sometimes gendered words are used in a specific sense and they don't imply every other gender. Probably one of the most controversial examples of this is in the Marriage Act. Now, the definition of marriage in the Marriage Act 1961 is the union of a man and a woman to the exclusion of all others, voluntarily entered into for life. Now, if we applied the idea that gendered words imply every other gender, then we could imply, for instance, that the use of the word woman in the Marriage Act also implied the word man, so we could read that definition of marriage to mean the union of a man and a man to the exclusion of all others, voluntarily entered into for life, which would of course make same-sex marriage perfectly lawful. Regrettably, it doesn't work that way. In this case, what you've got is a situation where the presumption that's established in the Acts Interpretation Act is clearly overturned. So there's a contrary intention in the legislation. The legislation is saying quite clearly these gendered terms are used in a very clear way to express only members of a particular gender. The other complication to be aware of when we're talking about gendered words is that until very recently, the law conceived of people as having only one of two possible genders, that is, male and female. Nowadays, we're becoming aware that the concept of gender and gender identity is much more complicated than that. And at the very least, the law needs to be able to accommodate not only males and females, but also transsexual people, transgender people, intersex people. And as we become more of a multicultural society, we need to start being able to recognize other cultural practices such as the Hira of India and the Whakalaiti of Tonga, where people may have the genitalia of one gender, but they conduct themselves and are socially recognized as occupying a gender identity that is neither male nor female, but something different altogether. Given that gender is now much more complex than a simple binary idea of men and women, we need a provision such as the provision in the Acts Interpretation Act that gendered words imply every other gender, so that we don't have to come up with 7 or 8 different sets of pronouns, or alternatively try and start coming up with systems of pronouns that are gender neutral across 6 or 7 potential genders. The next provision is that plurals and singular words are interchangeable. I use this for an example earlier on in this lecture. Generally speaking, plurals and singular words are going to be interchangeable. The example that I've used in the notes is section 143(1) of the Public Health Act in Queensland, which says a person must not recklessly put someone else at risk of contracting a controlled notifiable condition. So we're saying someone else. That's a singular term. What if you put a whole bunch of people at risk of contracting a controlled notifiable condition? Is that okay? I mean, it says put someone else at risk. You haven't put someone else at risk. You've put a whole bunch of people at risk. Well, of course, it's not okay. The reason it's not okay is that the Acts Interpretation Act includes section 32 capital C subsection B in Queensland and section 23 in the Commonwealth, which indicate that unless the contrary intention is clearly specified, plural words imply singular words and singular words imply plural. Next, I want to talk very briefly about provisions regarding may and must. Now, these are old friends of ours. We talked about may and must back when we were talking about professional vocabulary. The Acts Interpretation Acts have made a bold attempt to try to deal with the confusion between may and must. So we've got Queensland provision section 32 capital C capital A, which says the word may indicates that the power may be exercised or not exercised at discretion, and the word must indicates a power that is required to be exercised. And that's pretty much the same definition that we came up with when we were looking at the common law, that may implies a discretion while must implies a duty. I really wonder whether by putting this provision into its Acts Interpretation Act, Queensland has really changed anything. I don't think it's really resolved any of the disputes that one can still have about the meaning of provisions, about the meaning of may and must, and I certainly think that once you put them into their negative forms, it does nothing to help us understand the difference between may not and must not. So it was a bold attempt, but I don't think it was an attempt that was successful. Next, the last thing I want to talk about with Acts Interpretation Acts is that both Acts Interpretation Acts contain a dictionary, a series of definitions. Now, of course, we're familiar with the idea that most pieces of legislation contain dictionaries or interpretation sections. The interpretation sections, the dictionaries in Acts Interpretation Acts, however, they're a bit different because the definitions they give are intended to be read across the entire statute book. So the words that are included in the definitions in the Acts Interpretation Act don't need to be redefined in every single statute. The statute may redefine them, particularly if the statute is going to use the word with a slightly different definition to that given in the Acts Interpretation Act, but it doesn't need to. What does this mean for you? This means that in the past, if you have been interpreting a statute and you've gone looking for a definition in that statute and you haven't been able to find it, and you're surprised, you're thinking this is really an important word in the context of this statute, I'm surprised that I haven't got a definition here. There may well have been a definition, and that definition may well be sitting in the definitions section of the Acts Interpretation Act. It's worth checking out at the very least. The best example I can give is that quite often you'll find that statutory provisions relating to evidence don't include the definition of document. Why not? That definition is sitting in the Acts Interpretation Act. Other important words that are found in those definition sections: aborigine, estate, lawyer, magistrate, indictment, committal, territorial see, writing, spouse, will, justice of the peace, year. You can see that these are words that you're going to come across all the time in your statutory interpretation. You probably never even stop to think about the fact that they must be defined somewhere. Well, they are defined somewhere. They're defined in the Acts Interpretation Act. And if you're using them in your own legal writing without having checked what the law regards them as meaning, then you're writing with a blindfold on. So you really ought to take the time to become familiar with which words are defined in those Acts Interpretation Act definitions. That's all I want to say about the Acts Interpretation Act. So I hope that that's enough to whet your appetite so that you do spend some time really getting to know those Acts Interpretation Acts, really getting a sense of what's in them. You will find that many of your professional compatriots do not, which means that if you do, you'll have an advantage because you'll be the one who knows where to find these basic rules and basic guidelines for the interpretation of statute in both the Commonwealth and the Queensland jurisdiction. And for that matter, every other state and territory has a similar piece of legislation. I want to finish off today by talking about human rights. Human rights are an odd topic to talk about in Australia because almost alone in the Western world we don't have a Charter of Rights. And most people in Australia get a lot of their legal information by watching bad American TV. And the United States, of course, regards its Bill of Rights as one of the central documents which underlie the American rule of law. In Australia, if you tell people that they don't have constitutional rights, they're often quite surprised. They see these television programs coming from the United States of America and they assume that our system is so like that of the United States that they must have particular rights. Well, whilst the truth is that they don't, in the normal sense, there are still three sources of rights which Australian lawyers need to be aware of. The first one is common law rights. Now, we've talked already a little bit about common law rights when we talked about the common law statutory presumptions a couple of weeks ago. Those rights, such as the right to be legally represented in court or tribunal proceedings, such as the right not to have possessory rights to property taken away without adequate compensation, and such as the right of habeas corpus, that is, not to be arrested or detained without being brought before a court. Those are common law rights, but are very strongly protected by the courts. What that means is that if we are writing statute, and those statutes are going to compromise those rights, we will need to be very careful to make sure that the court is fully informed about the fact that the Parliament has considered the abrogation of these rights and the Parliament intends to proceed anyway. Most of the time, the abrogation of these rights is regarded as such a big deal that the Parliament will back away from them. On top of that, in Victoria and the Australian Capital Territory, they've now adopted a Charter of Rights. The interesting thing about these Charters of Rights, however, is that they are just normal pieces of legislation. And so a Parliament is not bound by a Charter of Rights. A Parliament can overturn the Charter of Rights or change it or legislate around it any old time it likes. However, the idea of the Charters of Rights, that's the Human Rights Act 2004 in the ACT and the Charter of Human Rights and Responsibilities Act 2006 in Victoria, is that the Parliament has drawn a line in the sand. The Parliament has said, our intention is to legislate in accordance with this Charter of Rights. And we're empowering the courts to tell us if any legislation is outside the Charter of Rights. Now, that doesn't necessarily mean that once the Supreme Court of each of those jurisdictions identifies a piece of legislation as being contrary to the Charter of Rights, the Supreme Court can't strike it out. But the Supreme Court can certainly rule that the Act abrogates those Charters of Rights, can report the fact back to each state parliament, and that's going to carry a very high moral imperative, certainly a high imperative amongst the voting public, to have the Parliament change that legislation. Third and finally, Australia is a party to a range of international obligations, so obligations under international law. Those obligations are not binding on us in the normal sense because international law has no sovereignty. They are binding on Australia because Australia chooses to submit to the binding authority of those instruments. But given that Australia has done so, there's a very strong expectation that our domestic legislation will comply with the international obligations that we as a country have freely adopted under United Nations and similar conventions. And there's a bunch of them. I've listed some of them in the notes. So there's the International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Covenant on Economic, Social and Cultural Rights, the Convention on the Elimination of All Forms of Discrimination against Women, Convention on the Rights of the Child, Convention on Rights of Persons with Disabilities, and so on and so on. What you can see is, like the Charters of Rights in Victoria and the ACT, and indeed like the common law human rights in Queensland, the Commonwealth and elsewhere, these international obligations do not actually prevent the Parliament from passing legislation which abrogates those rights. The courts cannot strike out legislation, even if that legislation abrogates human rights. However, the UN conventions, the Charters of Rights and the common law rights in the Queensland and the Commonwealth do present a standard, and they do enable the courts, the opposition and any other interested stakeholders to stand up and argue if the Commonwealth or Queensland Parliament abrogates those rights, that this is not good enough. Generally speaking, if the courts can give an interpretation of a piece of legislation that is consistent with those rights, the courts will do so. So if you are interpreting or writing a piece of statute in an area where these sorts of human rights are important, you must understand the rights, you must understand their sources, and you must understand their implications, because they are very likely to influence the way in which the court assesses your piece of legislation. Well, that's it for this week's lecture. For most of this week's lecture, we've talked about the Acts Interpretation Acts and the fact that they provide general guidance across all of the relevant body of statute law. We've looked at two separate Acts Interpretation Acts, the Queensland and the Commonwealth one. We indicated that they share a lot of their detail, but they're not identical. We've looked at a range of the most important provisions, including the dictionary provisions. And finally, we've talked a little bit about various types of human rights, in particular common law human rights, charters of rights and international obligations, and talked about how they have an effect on the interpretation of statute by the courts. Next week we're going to start drafting. We're going to spend a couple of weeks looking at different skills of legislative drafting, and then we'll conclude the semester by looking at the process of drafting some other non-legislative types of documents. I hope at this point, having completed all of the material related to statutory interpretation, that you feel in a much stronger and more expert position to interpret the statute that you deal with in all of your legal studies and in future in your legal practice. Now we're going to put the shoe on the other foot and have a go at actually writing some legislation. I look forward to talking to you next week so we can give it a shot.